Well, dear friends, dear colleagues, um, I guess the minister has left, but I have entitled my talk, It is the Duty of Every State. And I think some of you will recognize the phrase. If you don't recognize it, and if you were paying attention, the minister read the whole line, which is from the preamble to the Rome Statute of the International Criminal Court. And it says it's the duty of every state to exercise its criminal jurisdiction over those responsible for international crimes. So I want to explore that notion a little bit as to what that duty might be, where it comes from, and what its scope is. This is an international law instrument, the Rome Statute. So the duty must be found in international law, and that means that it must be found in one of the sources of international law, essentially customary international law or treaty law. I think when it comes to customary international law, it's extremely difficult to figure out what the scope of this obligation might be. We talk about it a lot, about customary international law, and it's a favorite trope of academics, activists, and so on to say that something is customary international law, but it's not always so easy to actually demonstrate it. Some years ago, the International Committee of the Red Cross prepared a study on customary international law of international humanitarian law, and looked at the question of war crimes specifically, both in international and non-international armed conflict. And while they found an open door when it came to international armed conflict in the grave breach provisions of the Geneva Conventions and the first additional protocol of 1977, the evidence is much weaker when it comes to non-international armed conflicts. Of course, when there's a non-international armed conflict and serious crimes are committed on the territory of a state, it's not really controversial to say that that state has an obligation to punish those serious crimes committed on its territory. But is there an obligation to go beyond that and to prosecute crimes committed by people who may be on the territory of the state but committed the crime elsewhere? And as I say, that's not really straightforward, not easy to demonstrate. I don't know how many of you will have studied the customary law report of the International Committee of the Red Cross, but once you dig into the references, sometimes the support is a little on the frail side. The International Committee study is more of a campaigning document in that it tries to argue for a norm than a serious, balanced study that looks at evidence both for and against the norm. So I think it's not really straightforward at all to claim that there's a duty on states under customary international law to prosecute international crimes committed outside their territory and arguably by people who are not their nationals. The obligation exists in some treaties, and I've already mentioned the key one, which is the 4 Geneva Conventions and the first optional protocol, which provide in some fashion for an obligation to prosecute under, this is under treaty law, but with respect to international armed conflict. And there, the only problem, I mean, I can't think of a provision in a treaty that's generated more heat than light than the grave breach provisions of the Geneva Conventions. We always talk about them, but there are very, very, very few prosecutions of the grave breach provisions. It's a positive development, really. It just means there are very, very few international armed conflicts. And so there's been very little evidence and very little requirement for those prosecutions. Mainly what we're talking about are either non-international armed conflicts or atrocities committed in peacetime. And there, of course, we also have other treaty provisions, the Torture Convention, the Enforced Disappearance Convention, but these have not been ratified universally. And the draft Convention on Crimes Against Humanity, which is to be debated in the General Assembly in a week or two, I think, today. Okay, it's being as we speak, so maybe I'll have to come back tomorrow and give you an update. It calls for a duty to prosecute crimes against humanity under the treaty. I don't know how well accepted that's going to be, how many states are prepared to accept such a broad obligation to undertake such prosecutions. Because I recall a conference I was at, I think in Bucharest, several years ago, where a representative of the Canadian government, Joe Rykoff, who worked for the Justice Department, I think in Canada, was a speaker. And someone made one of these statements about how the duty to prosecute adjudicare was undoubtedly customary international law with respect to crimes against humanity. And he said, not as far as my government's concerned. As far as my government's concerned, we don't have any obligation. I'm talking about an obligation to do it, not the possibility of doing it. That's a slightly different question. That's the question of universal jurisdiction. I think that that subject is going to return again and again in the 3 days of this conference, prosecutions on the basis of universal jurisdiction. Again, the problem with prosecutions on the basis of universal jurisdiction is that they tend to confirm the absence of an obligation rather than the existence of one, because there are so few of them. And we know that states cherry pick the cases that they're going to do for a variety of reasons. Years ago, I used to say that they had a preference for their former colonies. That was certainly the case with Belgium and maybe Spain. But I think it's broader than that today, and there is arguably more activity in the area of universal jurisdiction, but it's still very, very limited, and it certainly doesn't show the existence of a duty, the sense that states are under a duty to undertake such prosecutions. There's one other provision in the preamble of the Rome Statute that addresses this issue as well. And I'll read this paragraph. It says, their effective prosecution, referring to international crimes, must be ensured by taking measures at the national level. So it says taking measures at the national level, but we're talking about prosecution. So that tends also to reinforce the message in the preamble. I looked through the case law of the International Criminal Court to see how often these provisions are cited. I came across only one recent reference to this idea of the taking measures at the national level. It's in the Katanga case. So Katanga was one of the first people to be prosecuted. He was kind of a part of the team of Lubanga and Katanga. And Katanga was, when he got to the court, unlike his friend Lubanga, he challenged the admissibility of the prosecution against him on the grounds of complementarity. He said, I come from a country where the courts are functioning, where I can be prosecuted, where I've been charged, where I've been in prison. Why do I end up in The Hague? And this was at a time when the judges had developed a very benign approach to complementarity. So instead of ruling that a state was unwilling or unable to prosecute a case, which seems to be at first glance the message in Article 17 of the Rome Statute, they said, well, a state was inactive. And that was really just a matter of a state deciding, we don't want them, you take them. And that too isn't really consistent with the idea that it's the duty of every state to do this. And the court might well have turned to these states and said, actually, it's your duty. You're able to do it. So Katanga instead ended up in The Hague, and he was tried and convicted and got his sentence, and he served his sentence, and then they sent him back to prison in Kinshasa. And to his surprise, when he got to the prison in Kinshasa, he learned that the Congolese authorities were going to prosecute him for other crimes. And he went to the court and said, well, this is to the International Criminal Court. And he said, well, this is a bit unfair. First of all, you told me that I couldn't be tried in the Congo. You brought me to The Hague, tried me here, put me in prison for 10 years. And now you sent me back to be prosecuted for something that could have happened 10 or 15 years ago. And the judges, this was a decision by the presidency of the court, 3 judges of the presidency, referred to the provision about the effective prosecution must be ensured by taking measures at the national level, and said, well, Congo's just doing what it has the right to do and what it should do under the preamble of the Rome Statute. It's not exactly a double jeopardy case because he was being prosecuted for other crimes, but I don't think we'd take well to this if we did this in a domestic system where we had a trial of someone for some crime, let them serve the sentence, arrested them as they were leaving the prison and said, and now we're going to try you for another count of drug trafficking on another street corner in Vienna. We would find that there would be a whiff of unfairness about that. And without being able to identify a precise violation of the Rome Statute, I'd find there's a whiff of unfairness in treating Katanga in this way as well. It brings us, of course, to the subject of complementarity. The whole premise of the Rome Statute, based on the duty of every state to do the prosecutions, is that that's really the first stop. That's where prosecution should take place, and it's only when states fail in their duty that cases should come before the International Criminal Court. And that has led to a notion that we sometimes call positive complementarity. In a way, it's reflected in the way they dealt with the Congolese cases as well. Declining to condemn a state for being unwilling or unable to prosecute, and instead saying that the state was inactive. It was a gentle way of taking the case without having to make a pejorative assessment of the state's comment. But the court operates in another way, and this is really entirely extrajudicial and beyond the control of the judges, and that's at the very early stage, when the prosecutor lets a government know that she's either conducting what we call a preliminary examination, or sends an even more subtle message that she's thinking of conducting a preliminary examination. I say she, I'm going to have to start changing that. He, with the new prosecutor, Karim Khan. So we had a conference at Leiden University some years ago on this notion of the preliminary examination, which is something that was, it's in the statute, in a little phrase in the statute, but it has become a huge, out of proportion to, I think, what was ever imagined when the Rome Statute was adopted. And so we held this conference as this phenomenon was starting to become very, very pronounced. We held it in the Academy building at the Peace Palace in The Hague. And we expected a usual crowd of doctoral students, NGOs, academics, and so on. And there, when the conference opened, in the front row were a bunch of middle-aged men well-dressed in suits with polished shoes and so on. They were ambassadors. And we don't normally get ambassadors. I don't know if there are any ambassadors in the room, but we don't normally get them at our conference. And they were ambassadors not from countries where there were investigations underway, and not from countries where there was a preliminary examination underway, but from countries where they were afraid that there would be a preliminary examination, and they'd been sent by their capital to go and learn about this phenomenon and make sure that they didn't get on the list of countries under preliminary examination. I think the most celebrated case of the preliminary examination is that of Colombia in South America, where, of course, there was a terrible civil war for decades, and where immediately at the very beginning of the International Criminal Court, the prosecutor said, I'm looking at Colombia. Colombia is on the list. And it was an open secret even before they published lists of countries under preliminary examination. It was almost public. At one point, the prosecutor even made a submission to the Constitutional Court of Colombia. And the prosecutor's office in The Hague was deeply involved in a transitional justice program in Colombia. I was very nervous watching this process, although so far I don't think that it's had an unhappy result. Maybe even we can say a positive result. And the prosecutor has still not undertaken any, gone beyond the preliminary examination. But I was simply nervous that some specialists in transitional justice with master's degrees from the Geneva Academy or something like that would start meddling in a complicated domestic peace process, and applying mechanistically principles that they had learned and slogans, and that this would, far from assisting the process of transitional justice and of peace, would only complicate it. I'm not enough of an insider in that process to be able to tell you the difficulties, if there were any, but the potential is huge. And I think this is something that should be a concern in the future as the prosecutor continues to be involved in transitional justice programs, even where there's no prosecution that's going to result. At the Rome Conference, I attended the Rome Conference in 1998, and I recall the very active contributions of the then only prosecutor in the field of international criminal justice, Louise Arbour, at the time. She had become the prosecutor of the international criminal tribunals for Yugoslavia and Rwanda I think she took office in August or September of 1996. And she also, in a way, had the most experience. Her predecessor, Richard Goldstone, had done the setting up of the tribunals, but he hadn't really got into the prosecutions themselves. And she was not a fan of Article 17 of the Rome Statute. And she spoke on this, she lectured on it, and she wrote about it. And she said, this Article 17, which is the complementarity provision that says that the prosecutor, that cases and prosecutions where the state cannot be shown to be unwilling or unable should not proceed. She said, that's not going to work. She said, that's a recipe for failure. She said, the unable part of it, unwilling or unable, she said, unable, that will be a poor state in the South. She said, yeah, it won't be hard for me as prosecutor to demonstrate that that state is unable to provide a fair trial. I won't have too much trouble doing that. But unwilling, she said, and I think this was 1998. So I think what was on her mind was Croatia, mainly at the time, because Croatia was fighting the prosecutor of the International Criminal Tribunal for the former Yugoslavia, was objecting to producing documents and so on. And she said, a developed country's justice system will be able to run circles around me and will be able to fight off an investigation by claiming that they're doing things when it's hard to prove that they're not. And that idea has been sitting out there, and probably because for most of the cases that have come to the court so far, the states have been cooperative. Think of Uganda. We just had the conviction. I can't remember now. There's a blur in my mind when I say some months ago or some years ago. There's about 2 years that's missing in my mind somewhere. But think of Uganda when Dominic Ongwen was convicted by the International Criminal Court after a lengthy trial. Uganda's absolutely capable of holding the trials. I recall at the Kampala Review Conference where there was a panel on complementarity that I chaired, in fact, and we had a senior Ugandan judge, and he said, of course we can do all these trials. He boasted about the Ugandan justice system, and everyone thought it was great what was going on in Uganda. And yet the International Criminal Court took up the Dominic Ongwen case and prosecuted it. So those issues haven't presented themselves so sharply as they did recently. And now I'm referring to something where I can put a date on, and that was December of 2020. And that's when the prosecutor of the International Criminal Court, the former prosecutor, after spending several years examining the response of the United Kingdom to the preliminary investigation of acts of torture and prisoner abuse in Iraq, came to the conclusion that they probably aren't doing the job. They're probably not conducting a proper investigation. They're probably unwilling, but I don't have enough evidence to be able to prove it to the satisfaction of the judges, so I'm closing the case. And in other countries, I won't name them, but you can guess some of the candidates. In other countries that are under investigation or that are under preliminary examination by the court, we have a similar situation where a developed justice system is able to show that it appears to be doing something, and yet there's something missing. And one of the things that's missing in the United Kingdom is that still nobody's gone to jail for these crimes, which are not disputed, and where there have been handsome settlements out of court, and where there have been judgments of the European Court of Human Rights. The final idea that I want to put out here in this discussion, in this introductory talk to what promises to be a great conference, is that at the domestic level, when international justice arises at the domestic level, there are a variety of mechanisms and means of bringing justice at the domestic level. They're complicated. And they depend greatly on the judgment, on subtle, careful judgments by people at the domestic level. And we need to be very careful as coming from the outside with firm pronouncements about what should or should not be done. I've given the example of Colombia. But let me give another one that I'm very familiar with, and that's Sierra Leone. And as was mentioned in the introduction, I worked as one of the 7 commissioners of the Truth and Reconciliation Commission there. Some years ago, I was on a panel with Stephen Rapp. Stephen is an American prosecutor. He'll be well known to many people in the room. And Stephen worked he was prosecutor of the Special Court for Sierra Leone. He was prosecutor at the International Criminal Tribunal for Rwanda. He has a lot of experience. And then he served as an American diplomat and negotiator. And I think in a way he continues to do that work today. He probably had a 4-year gap during the Trump administration. And Stephen talked about the contribution of the Special Court for Sierra Leone. And he said, you know, isn't it amazing what it did? The country is at peace. Isn't that great? Thanks to the Special Court for Sierra Leone. And I'm sitting here thinking, could you at least mention the Truth Commission for Sierra Leone? Because he can't prove that it's the Special Court for Sierra Leone. You know, there were thousands and thousands of perpetrators of crimes in Sierra Leone, and the Special Court judged 10 of them, 11 of them, a handful. And in a strange way, we could say that the Special Court, although it is presented as a mechanism that was to confront impunity, it actually entrenched impunity for the vast majority of the perpetrators of serious crimes in Sierra Leone, who've never been prosecuted. So is that what did it? Or could it have been the Truth Commission? I can't prove it's the Truth Commission, but I can't prove it's the Truth Commission any more than he can prove it's the Special Court for Sierra Leone. The short answer is we don't know. And Sierra Leone, by the way, in the background, had this very controversial amnesty. Amnesty, I don't know if the subject will arise. Let me just say a couple of words about it, because amnesty is a controversial matter as well. There's also a rule on amnesty in the customary law study of the International Committee of the Red Cross that says no amnesty for war crimes. It's a rule of customary international law. Maybe the amnesty is what brought peace in Sierra Leone. We don't know, that's all. There are a number of possible explanations, and it remains something we don't know, to which we don't know the answer. On the subject of amnesty, and we discussed this in the report of the Truth and Reconciliation Commission, we said it's not for us to question the judgment of the peace negotiators who had to bring an end to a conflict as to whether or not an amnesty was a necessary ingredient. It's extremely hard with hindsight to look at a peace process and say, you shouldn't have had an amnesty. You shouldn't have done that. Maybe you wouldn't have had peace as a result. I view it as a pendulum, the amnesty issue, because again, in the study by the International Committee of the Red Cross, they are looking, they're embarrassed about the provision in the second optional protocol to the Geneva Conventions that says that at the end of the conflict, you're supposed to give the broadest possible amnesty. I want to say they've always been embarrassed about it, but they say they are now, or they have been for several years. And they cite a declaration by the Soviet diplomat when the treaty was being adopted in 1977, saying this doesn't include war crimes. And they say this is what the International Committee of the Red Cross agrees with. But if you read the commentary that was published by the International Committee of the Red Cross in 1987, 10 years after the treaty was adopted, they don't say that in their commentary. So they haven't always said that, but now they've discovered it. And we have judgments, and there've been a number of them, where judges they say the rule is crystallizing. They hesitate about saying it's crystallized. They say it's crystallizing. There's an emerging rule, but they can't quite bring themselves to say it's emerged. And so it's been like a pendulum shifting towards this, but the pendulum seems to have shifted back a little bit. And we have the example in the report of the International Law Commission on Crimes Against Humanity, which discusses the issue of amnesty and says, it's complicated. We're not going to put a provision in the draft articles on crimes against humanity about it. And we also have an interesting judgment from the appeals chamber of the International Criminal Court from about April of 2020 in the Gaddafi case, where they deal with the issue of amnesty. And they had a pronouncement at the trial chamber or the pretrial chamber saying, there's a rule of international law against amnesty. And the appeals chamber basically says, not so fast, not so fast. So my view has always been that it's wrong to rule out amnesty in these cases. It's fine to discourage it. It's fine to talk about the problems that arise from it, but that amnesty is one of those important parts of a peace process that has to be in the toolbox of negotiators when peace negotiations are being made. And that means that it's something when there are domestic prosecutions, especially those involving universal jurisdiction. I think serious thought and respect has to be given to some of the domestic decisions on these matters by other countries rather than disrupting. That, by the way, is what the international community did pretty much collectively with regard to the crime against humanity of apartheid committed in South Africa. And when Nelson Mandela died, I didn't hear anybody saying, what a rat, Nelson Mandela, because he gave an amnesty for the crime against humanity of apartheid. We respected his own judgment on the situation. I have one final point about domestic responses to international crime, and that concerns victims. As you know, the victim reparations part of the Rome Statute, although it's tucked away in a very small provision in the statute, has become a big part of the work. And there's a great deal of judicial attention to it, a great deal of activity, a great deal of academic attention to the provision of reparations for victims. The actual result in terms of what the victims have got is rather small, really, when we think of all the money that's been thrown at it. So we have, for example, a trust fund for victims that's been in operation now for a good 15 years that has a budget, an operating budget of somewhere between 2, 3, 3.5 million a year. So the trust fund for victims probably cost about 50 million over the last 15 years. From what I can determine, the most that individual victims have got is $250 each, the symbolic reparations that were given in the Katanga case to the people of Bogora, who got $250 each. There were not quite 300 of them. I think if we had them here at the conference in the room and we said, yes, but we got him convicted. Aren't you happy? Aren't you satisfied with that? And by the way, we spent a lot of money on collective reparations. And they might say, what's that? And then they would learn that there were probably the collective reparations involved some European consultants who went off there and got a fee that probably was bigger than 250 times the number of victims of the conflict. So I find it all to be kind of a big disappointment so far. We haven't yet figured out how to properly deliver reparations to the victims. But we do this at the domestic level. So here in Austria, as in most countries of the European Union, there is legislation providing for reparations for victims of serious crimes. So we do the trick. We actually do it at the domestic level here. And I read one of the most recent reports on this mechanism, which again is it's EU policy. You have to have it. And they talk about the amounts that are given. They say it varies depending on how wealthy the country is and how generous their spirit is, from several $1,000s to amounts in the millions. Well, I hope those people of Bogor don't read that and learn that in Austria, if you're a victim of a serious crime, you get thousands and thousands and thousands of euro in reparations, and they only got $250. One way to start dealing with this would be to change the European legislation so that we provide reparations to victims who are here in Europe, even if the crime took place elsewhere. Why not say to people who come here who are victims of crimes in other parts of the world, international crimes, saying, we don't discriminate. You're entitled to reparations as well. There we go. Well, I thought that was better than getting the note shoved to me by the chair. Thank you. I'm going to stop in a minute. I think that's one. It's not a perfect solution, but it would be a beginning. But I wish the minister was here now. She would probably be trembling in horror at the idea that she would have to propose to the parliament legislation whereby someone who was a victim of a crimes against humanity in the Democratic Republic of the Congo, but who was here in Austria, would be entitled to reparations. But I can tell you that if they are, they're going to be entitled to a hell of a lot more than the International Criminal Court gives them. And I can also tell you that we won't have the same kind of elaborate bureaucracy that we have at the International Criminal Court's Trust Fund for Victims. Well, the bell rang. I think that I hope that I've provided you with what a keynote is supposed to do, which is to give some provocative ideas for the conduct of the discussions. And I understand there's a few minutes left where I could answer a question or two if the audience has them, or disagree with me. I'm sure you all agree with everything I've said.